Last week during the Lieutenant Governor's press conference, where she claimed the Attorney General's office had given her bad advice but failed to say what that advice was, citing attorney-client privilege. Well, the Lieutenant Governor said that she was told to seek outside legal counsel in her battle with the Idaho Press Club. Well, within just the last half hour, we actually received an email from the Attorney General's office, and this is an email we've been looking for a few days now. In that email to the Lieutenant Governor's office, Deputy Attorney General Rachel Colts tells Jordan Waters, who is Lieutenant Governor McGeachin's chief of staff, that they do not believe that McGeachin could redact certain information as a part of the press club's public records request. The email, which you're looking at on your screen right now, it explains that and ends with giving the Lieutenant Governor the option to seek outside legal counsel should she not agree with the AG's opinion. She did disagree with the AG's opinion, and she went and got her own outside private counsel. The Lieutenant Governor very clearly didn't like the advice from the AG, which is fair, so she found another opinion. But there are still a lot of unanswered questions about that private counsel to McGeachin's office and her legal battle with the Idaho Press Club. One of the biggest questions, how much will this whole ordeal cost Idaho taxpayers? And here's what we know so far. McGeachin was fined $750 by an Idaho judge for what he called bad faith violations of the Idaho Public Records Act. Now, that stems from McGeachin initially refusing to release public records from her education task force. She eventually did release those records one day after the press club asked the judge to hold her in contempt of court for failing to do so. Now, on top of the fine, the judge in the case ordered McGeachin to pay $28,596.50 in court costs and legal fees. Now, those are the legal costs that the Idaho Press Club had during their successful case. That number, though, $28,596.50, does not include private legal fees that the Lieutenant Governor accrued after she opted to not work with the Idaho Attorney General's office on the case. Interesting to note, though, in late August, the Lieutenant Governor submitted a supplemental budget request to the state of Idaho. The total being, quote, $50,000 to pay for legal bills that cannot be covered by the Lieutenant Governor's office current budget without reducing staff hours and constituent services. That $50,000 in taxpayer funds she requested will be brought before the Joint Finance and Appropriations Committee as a supplemental budget item to the Lieutenant Governor's 2023 fiscal year budget, and that'll happen sometime this week at JFAC. But how did her office come up with the $50,000 when she was charged just over $28,000? We submitted a public records request asking for any records involving outside legal fees and consultation. I got a response today from the Lieutenant Governor's office in regard to that request, and I'm going to read it basically in full here. This was an email sent to me this morning. Quote, specifically, the Lieutenant Governor is denying your public records request on outside legal consultation. Attorney-client privilege is part of state law, see Idaho Code 9-2032, and is further explained in a different part of Idaho Code. Email went on to tell me that furthermore, Idaho Code 74-104 clarifies that any public records made exempt from disclosure by the state or federal law are also exempt from disclosure under Idaho Public Records law. Now, records between the Lieutenant Governor's office and that of legal counsel are protected by attorney-client privilege and therefore exempt from disclosure. As of this date, the office has not received any invoices for outside legal fees. Again, the official response from Lieutenant Governor's office. So for now, that response I gave you, that's the answer. But to be clear, though, the Lieutenant Governor is allowed to talk about whatever she wants. Attorney-client privilege here doesn't prevent her from talking. She can choose not to, but she is not legally prevented from telling Idaho taxpayers how much money she spent on legal fees with a private attorney. And late this afternoon, we received another letter, this time from the Idaho Joint Democratic Caucus. They tell us a lot of things, and all four of the people signed on at the bottom of this letter are Democrats and are members of the Joint Finance and Appropriations Committee. And they're asking the Lieutenant Governor's office to release several pieces of documentation, including the Attorney General's opinion, how her office plans to pay her legal fees, an unredacted copy of the engagement letter between McGeachin and her private attorney, and copies of all the legal invoices. The Democrats say that those documents will help them make a decision on whether or not to grant the Lieutenant Governor's request to get $50,000 in supplemental budgeting. Now, as they also point out, McGeachin is not bound to attorney-client privilege as she is the client and can release any information she wishes. Now, to be clear, it may not be the best option for the Lieutenant Governor to speak publicly on that, which is understandable. But to be clear, she is allowed to release that info. She is choosing not to.